You're all set.
Thank you. I will call the meeting of the Public Safety Committee to order on November 16th at 7:03. We have staff on the call. I believe we have Attorney Bayer and Manager Ewald. Anyone else from the staff? Okay. And any media on the call? Okay. I did get a text from Trustee Bachhorst, likely won't make committee tonight, so start without me. So Trustee Warren, it's you and I. My intention is to go over the materials briefly, and we'll have a discussion if we need staff input. Attorney Bayer's here, and obviously Manager Ewald. My intention is not to take public comment because I think what we have before us is similar to other affidavits of complaints that have been filed with the village, and we'll follow precedent and staff recommendations. At this point, you and I will be discussing with their input, and we'll leave it at that, if that works for you, Trustee Warren.
Oh, thank you, Trustee Stoker-Brand. Yes.
Okay. All right. So we have the information in front of us, I believe. The three things in the file are, let me just get my file up here. We have the complaint, President Rozek's response, and then a statement from Mr. Carlson.
Trustee Stoker-Brand.
Yes, President Rozek.
I do have a point of order whenever it's before we start the committee that I would like to ask, but it can be at any time when you're finished.
Let's just do it. Go ahead.
Thank you. The memo, I just had a question, if it is correct. The complaint alleges, and it states in here, that there's an email that alleges that we're presiding over the matter, the committee is on bias. And I just wanted to point out that the complaint does not allege that. The complaint alleges that on paragraph 6, that it's for cause based on 19.59 Wisconsin statute prohibiting any commissioner from taking action that blah, 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 blah. And they cite the statute section. So I don't know if that's just an oversight, but it conflicts.
We will take that into consideration. Thank you. Okay. Trustee Warren, do you have any comments?
I do. I'm trying to get to the packet so long. I'm trying to scroll down in it right now. This is why I like paper, but
yeah, find 204 in the packet, I believe.
204. I realize it's better. It's better environmentally to not have paper, but
I know
it takes me a little bit to get there. So the for cause bar seems very high here, and again, I'm still getting there. But when I was reading it, it says malfeasance and a couple of other things. So I was wondering if we could have a couple sentences from our village attorney as to, from my viewpoint, it looks like the for cause bar is a bar that's very difficult to meet, especially in these circumstances when you're talking about a retweet. So I would like to get the viewpoint of our attorney on whether this is something that would traditionally constitute for cause under Wisconsin law, because it doesn't look like this would rise to that level in this case to me. So I'd like to hear the legal perspective on that.
Attorney.
Sure. Thank you. Can you hear me okay?
Yes.
Yes, thank you.
Sure. So what I can tell you is what the definition is that's been included in Chapter 17 of the Wisconsin statutes, which was the basis upon which the partial basis upon which the complaint was premised, and it defines it as I've included in the memo here, or was included in the memo, as I might say. So I think one way to look at it, and again, I don't want to render an opinion as to whether or not it meets the standard or not, because that's really a question for the committee and then collectively the board and the village. But I think if you read the complaint, what they're really saying, for all intents and purposes, is that that the concern is that would he be able to preside over disciplinary matters related to the police department moving forward, or as a practical matter, would, you know, I guess that begs the question as to whether or not he would have to recuse himself or not. And if the answer to that is no, well, then of course there's, you know, then it doesn't meet the standard of cause. And then if the answer to that question you think is yes, then I think you have to discuss further as to whether or not, you know, how that relates to the definition of cause, how it relates to, I'm looking at the definition here under 17.001, whether that might constitute inefficiency, neglect of duty, misconduct, or malfeasance. You know, I think then, you know, really the question probably comes down to inefficiency or neglect. If, as a practical matter, you're a sitting police commissioner that, for all intents and purposes, can't sit on any disciplinary matters, which is, you know, sort of one of the functions of the police commission. But if you don't think that it does, then I don't even think you get to that sub question, really. So all I can do is refer you back to the definition that's provided in 17.001 and use that to guide your discussion. You know, your discussion of what the role of the commissioner is, what their duties and responsibilities are sitting on the commission, and whether or not that might interfere, whether or not the post might interfere and create an issue in terms of conflict of interest if he's got to sit in on a matter related to disciplinary. So again, that's all I can tell you. I can't tell you whether or not it meets the standard or not, because that's really for the body to decide as a whole.
And just to follow up here to my previous question, in this hearing itself, we don't need to make a determination at all, right? We can just receive this report, and under the ordinance, receipt of the report is enough, and that satisfies the ordinance. And if the aggrieved party really thought they had a strong case here, they could go directly to the circuit court judge. That's a result that can happen under the operation of our ordinance, correct?
Well, that's a two-part question there. So the first part would be, yes, receiving the report absolutely satisfies the requirement on the ordinance. And then however you want to report back to the full board, that's up to the body. The second part of the question is whether or not the police union that made the complaint could theoretically take it directly to the circuit court in this county. The statute talks about having to be a resident taxpayer of the jurisdiction in which the official was alleged to have conducted the misconduct. So that body, I don't know whether any of their individual members live within the municipality or not, could do it. So, but generally, they might be able to, they might not be able to. I don't know where all the individual members live.
Okay, thank you. I'm sorry I have to interrupt. I do see a participant on the call, WTMJ. Could you please recognize yourself, identify yourself? I had asked for media, if media was on the call. Is there someone there from TMJ?
Trustee Stokebrand, I've asked them to unmute, and there's been no change in their status.
Okay, that's regrettable. Okay, let's move on.
Trustee Stokebrand?
Yes.
I think that my point of order wasn't answered, and it goes to Trustee Warren's question. The ordinance, I don't know where this compared to malfeasance came from, but our ordinance states that charges against any officer of the village shall be preferred in writing by affidavit, and having been read shall be laid on the table, referred to committee for investigation without debate. I don't know where the rest of that process came from, but the point of order was not answered, and that is the association is complaining pursuant to 17.13 Wisconsin statute that it's requesting that we consider the matter for removing the commissioner for cause. And then, so that section is about bribery. And I'm just wondering why and how we got to the charges of bias as the only thing we're comparing when the actual complaint cites 17.13 Wisconsin statute for cause. And I think Attorney Bear probably could answer that.
Well, I think it's my understanding that cause is defined under 17.001.
But
No.
they're pursuant to 1713, that is the reason that they're asking for cause in 1713 and 1959. The actual complaint is citing two sections of Wisconsin statute, neither of which talk about bias as the cause. They talk about bribery. So I'm just wondering where a point of order is the complaint is, I mean, if you look at paragraph 6, it's completely, I could read the whole paragraph, but Attorney Bear probably could answer.
Sure, well, I'd be happy to. I'm not sure how anyone could read the complaint in its entirety and conclude that there was an allegation that the commissioner took a bribe. There was a passing reference to 1959. I personally had a conversation, the attorney for the police union had called me after to ask about the process and what the next steps were. And I told him that it was being referred to committee. And I asked him about whether there was any allegations associated with 1959. And he told me, no, of course, we made a passing reference to that. And it was, we're obviously alleging, of course, that the issue is whether or not he can reasonably sit and address disciplinary matters, or whether this would preclude him from sitting on those matters as an active commissioner. So if you read it differently, then
But
that's fine.
And what is the law about bias? How does that meet malfeasance? I mean, how would a committee judge or the village board, when it gets to us, where's the law that we compare that against malfeasance? It's not that section.
Well, I mean, we included a definition of the word in there, but I think probably, let me just find the memo again.
My specific question, just to be clear, was what's the section of the statute that talks about bias, so we can compare that charge or cause, removable cause for being biased against malfeasance, misconduct in office. There's not a section that I have in reference.
No, they're under 17001. They don't further define any of those terms. But frankly, I mean, I don't think in terms of malfeasance.
I'm not asking about malfeasance. I'm asking where in the Wisconsin statute, if it's not 1959 that's cited, is bias a reason for cause, so that we can compare what the charge is against the law. Where does it say that bias is against the law, or that we could even consider that for cause?
Well, the way I would explain that, first of all, with respect to 1959, which is titled, it's the Code of Ethics for local government officials. It is, again, I don't think has any applicability here at all. Those generally relate to financial interests and addressing financial conflicts of interest and those types of things. If you read the complaint as a whole, there's multiple references to Chapter 17, and there's reference to cause. And so the question then, I think, becomes
My question
whether,
was
yeah, go ahead.
I'm sorry, President Rosa, could you please let Ms. Attorney Bear finish?
I don't want to waste his time, but go ahead.
So I think it doesn't really have anything to do with 1959. I think we're really just looking at the cause question, and where it comes in, where I think it comes into play is if you had a situation, a hypothetical situation where you had a plan commissioner, for example, to take it out of the realm of the police commission, who was, as a practical matter, had to recuse himself on every single request for a variance that came before the body because of certain affiliations that he had. Well, good, bad, or otherwise, as a practical matter, it might be it might be an issue where they could physically not perform the duties or the functions of their role that they were assigned. So here, really, I think when you look at the definition, you're looking at whether or not the recusal would create a situation under 17.001 that would, as a practical matter, lead to inefficiency, neglect of duty. I would tend to agree with the comments that were made earlier that, this probably doesn't, the malfeasance or the misconduct might be, less germane to the inquiry than those other inefficiency or neglect of duty that's baked into the definition. So, but it's for the body to decide collectively based upon the definition that's in the statute.
Thank you, and still didn't answer my question, that's why I wanted to clarify again. They reference in the complaint 1959, which was the wrong reference, is my assumption, as for cause based on 1959. And since we're judging bias, I just want to know the statute section that says that bias is a reason for cause to be removed. Is there a certain section in the Wisconsin statute to reflect that 1959 that was a mistake?
I guess I just don't understand this need to have, like, narrowing it down to bias.
Because that's what the memo says. That was my point of order. The memo is stating that is why we're judging this. We're judging whether he should be removed for bias or cause. I don't know where that is in the Wisconsin statute.
I think we're just judging whether or not he should continue to serve on the police commission based upon the tweets.
What we're supposed to be looking at. That's the complaints request, removal for cause. So I just want to know where it says that bias is removed for cause. It says that bribery is, but that was an incorrect section that was quoted according to Attorney Baer.
Well, I think you can, if you want to reach out and ask, the complainant about what they're relying upon within 1959, I think the answer is probably nothing.
So
I think that the way I read the complaint and the way it was explained to me when I spoke with the attorney for the union was that they were relying upon 17001 and asking for consideration for removal for cause.
For being biased. Okay, thank you.
You can read the complaint. That seems to be the issue that it raises.
None. Okay, thank you.
Okay, Trustee Warren, did you have any further questions or?
Yeah, just thank you. The way I'm seeing it, bias would come in if it led to Commissioner Carlson having to be excused, having to recuse himself from things in front of the police commission, which would cause then inefficiency and potential neglect of duty. But I think in having that conversation, we're skipping a bunch of steps. I just don't know that we can assume that Commissioner Carlson would need to recuse himself from all these different things in front of the commission. In my view, just to kind of bottom line it, when you're talking about cause is defined as inefficiency, neglect of duty, official misconduct, or malfeasance in office. I see that as a very high bar, and I wouldn't support us taking action on removal based on retweeting what was retweeted. So, I think that we're doing our duty in receiving the complaint, and we're operating under the ordinance, but I would not support, further action based on these retweets, given the standard that I'm seeing. I'll end my comments there.
Okay, I would tend to agree. I think we have a lot of diverse voices in the village, and those voices should be heard, whether or not these retweets constitute something that is insurmountable when it comes to a personnel decision. I can't say that it definitively would, that it would merit removal from a commission. Poor judgment, possibly, but removal from a commission, I would agree with you, Trustee Warren. So if we're in agreement, then I don't know if we need a motion. It's just the two of us and we are agree. So I believe by consensus, if it's okay with you, I will just add then that we have decided that the complaint does not reach the level of removal from the commission.
I think we need a vote. Is it a 2-0? We'll report it back to the board.
Thank you, President Rosick. We'll take a vote. I'll make a motion. I move that we report back to the village board that We have taken under consideration the complaint, and the committee has decided to not recommend removal.
I'll second that. I think that, or can I ask, now that I've seconded, can I ask, Rebecca, does that give you what you need for the,
Sorry, I had to unmute. Yes, thank you.
okay,
You just need to vote.
okay.
All in favor, say aye.
Aye.
Aye. Opposed? Okay. All right, well, in the nick of time, thank you very much. I appreciate your time.
Just
We need a
move to
motion
adjourn. That'd be
to adjourn.
great.
I'll move to adjourn.
I'll second, and all in favor?
Aye.
Aye.
Thank you, everyone.
Meeting adjourned. Thank you.